Hey, folks, what's going on? Hope everybody's having a good Friday night. Pretty excited about this Free for All Friday episode. Willie, it's good to see you. John, it's good to see you. Let's see. We'll give it a few more minutes for everybody else to pop in. If you are on here, if you want to go ahead and throw up just a hello so we can see what you got going on.
Oh, more people coming in.
Yep. Just give everybody a couple of minutes. Jamie Lee McFadden, how you doing, man? Good to see you. Michael Hinn, hello. Good seeing you, man. Glad you guys made it. Let's see. All right, Bill, while they are, everybody's clicking in here, first and foremost, I want to tell you, I really appreciate you coming by. I think this will be a really good and timely discussion that we're going to have with you. You and I have talked about doing something like this for a long time and prior to COVID, and then we never got around doing a live event. But I think this is this is definitely one of those situations where I think we'll get actually more attendance, because not everybody can always go out to a live event, spend a few hours talking about self-defense law, but this is an extremely important topic. And for those of you that have attended any of our concealed carry courses, a lot of people have gotten frustrated at me because this is a topic that I just won't touch. When they start asking me about legal stuff, I'm like, man, look, I'll tell you tactics. I'll tell you what I would do. But as far as legal advice or whether or not you're going to go to jail, that's not something I'm going to tell you, talk to you, or do anything else. It's way outside of my scope. And without a doubt, Bill is the man, in my opinion, to address this topic. And we're really excited to have him on here, and really lucky to have him on. And we really appreciate it, Bill. So before we get started, Bill, if you want to just talk a little bit about yourself and just introduce yourself to everybody beyond what we kind of put in your bio on the intro page.
Sure. Thanks, Gary, for having me on. And Summer, it's good to see you guys again, and I appreciate being here. Bill Powell, I think as the bio said, I've been a lawyer for over 36 years in West Virginia. I've done everything from private practice to criminal defense to prosecution, both state and federally. My last job before the current private practice job I have now was as the United States Attorney, which is the chief law enforcement officer, federal law enforcement officer in the state of West Virginia, at least for the top 32 counties, northernmost 32 counties. That gave me obviously a lot of insights as well. But for many years, I have given presentations on self-defense law to lawyers, to law enforcement, to the public, not only in West Virginia but across the country. And it's something that I've taken my time and spent a lot of time with, getting to know about, watching videos, watching trials, etc., to learn as much as I can. So that's what I do. I'm obviously also, I've taken several of Gary's classes and other training classes, and I've been a shooting enthusiast for quite a number of years. And so that's nice that I also carry a firearm on a fairly regular basis, and have trained myself up, I think, pretty well with Gary's help over the course of years to become better, at least more proficient with a firearm than I was before. But just to start off, Gary, what I always tell people is that and I think Summer and I were talking just briefly before the show started, and that was that, notwithstanding how important trigger pull is, or body mechanics and stance and breathing and all the other things that you teach, is equally as important, I think, and really overlooked by a lot of people, is the legal aspect. It's great that you can use a firearm, but when can you use a firearm? How can you avoid getting yourself locked up or, in serious legal consequences because you don't know what the rules of the game are, what the rules of where you are at are, so you can act in an appropriate manner. What I always tell people is that, if having a firearm on you and then having to use it possibly, it often kind of reminds me of being in high school, in the sense that sometimes you had a test, or that you had to, you had to study for it, and let's say you had a test and you really studied and you were prepared, you read everything, you outlined everything, and you were ready for the test. And when you got the test, you felt comfortable and confident, and you went ahead and answered the questions and felt really good about it, without a lot of angst and anxiety. And I've also had experiences, as most of us have had, that you get a surprise quiz or a test you kind of blew off and didn't prepare for, and they hand you the questions, and you're like, oh crap, and the sweat starts beating up, and you get the knot in your stomach, and you're thinking, now what do I do? And you're trying to figure out how to do it. It's much the same way in a firearm situation, where you have a firearm, and it's possible that you could use it, but you're afraid to use it because you're not sure you're going to get in trouble if you use it. You don't know what your rights are, you don't know what their rights are, and it's a very and obviously, in those situations where sometimes it's life and death, freezing or not being able to act in a timely manner can be really consequential to you or other people. So it's one of those things you should know about. And I think most people, once they have a basic understanding of the law, they feel much better.
No, I think that from a tactical standpoint, we try to take or try to portray to our students the importance of a holistic approach. And just like you said, when you're sitting there, you don't have time to think about, hey, am I going to go to jail? Can I legally shoot this person or not shoot this person, for, a lot of different reasons. So anyways, no, that's absolutely on point. And I think most people that do get a gun, I think 90% plus of most firearm owners, besides getting a gun, that's really the beginning end of their thought into that process. And they think that, hey, I can use this gun, or I don't know what they think, but I know that they haven't put a lot of thought and time and preparation into being able to use the gun professionally, never mind ever thinking about having to actually get into a gunfight with that, and or the legal aspects of that. So these are all things that are really important, and something that I've been wanting to incorporate more into what we do. But again, it's definitely outside of my scope, but definitely being able to do things like this, I think will definitely help our clientele, and just in general help Second Amendment rights. One thing I've always been curious, Bill, I'd like to kind of get your take on is, honestly, you're one of the few lawyers that I know that actually is a pretty avid shooter to begin with. And then of course, a lot of the other folks that I've had contact with that are in law, they may do some shooting, but I think for the most part, I don't see a lot of folks in law that are actually into shooting. And I think it's really important to have folks like you that are not only avid shooters and enthusiasts, but also obviously defenders of the Second Amendment, because I think that is very, very rare. Why do you think that is? And is that a misconception on my part, or do you see that, you were even in Washington having to deal with that crowd? What is that like?
Yeah, there's a lot of that going on. I mean, I think most of us, you included, you see stuff on television, people trying to describe firearm scenarios or shootings, and you just cringe at the falsity or the failure to comprehend basic facts or fundamentals of firearms. And that's true. Certainly lawyers are probably no different than anybody else. Some that are shooters and understand it, but most notably from our standpoint as a concealed carry permit holder, the prosecutors often don't have a clue about firearms or ammunition, or when you can use it, and what what various things are. We talked a little bit about the Rittenhouse case and earlier, and we can certainly raise that again today. But that prosecutor, he knows less than my children about firearms, and it's plain from the various questions that he asks. They're almost laughable to anybody that understands firearms, but and it's, to be honest with you, it's really no different than being around Thanksgiving dinner with some family members and I grew up in New York, and you had some people like that and talk to me about hollow point bullets that they call them cop killers and other things, and we have that discussion. That's always a fun Thanksgiving dinner topic. So yeah, it's frustrating, but I think part of our responsibility, at least I think it's part of our responsibility, is to have a civil conversation with people. If they're really interested in learning, then we educate them. and we talk to them about it and explain why what they're saying is either wrong or misapplied or whatever the case may be.
Yeah, no, I think the more lawyers or people that are in the legal system to begin with that we can get involved in the firearms community, and just get them educated, I think we'll definitely get more people on our side. And again, also making sure that if you consider yourself a Second Amendment supporter, making sure that you're doing the right things and doing things like this where you are educated in the law too. And that's something that, I feel like I've done a lot of research, but again, the problem is I don't know what I don't know. And I think a lot of people in this, we think we know. We're Twitter lawyers, right? We're lawyers on social media.
Google lawyers.
We're usually either Twitter lawyers or virologists on social media. We got a lot of hats to wear, and we're usually pretty good on social media. But the reality is we don't know what we don't know. And unfortunately, just like you said, it is shocking to see how because a lot of the hysteria around firearms is based on a lack of knowledge, right? So. And that goes with in a lot of different areas, whether it's the ballistics of that, like you said, the prosecutor in the Rittenhouse case said that hollow point bullets explode inside their targets to make sure that they won't go past, into another target. So, it's those types of things that people believe, and people, even just when we're conflating semi-automatic with automatic weapons and so on and so forth. So there's a lot in there that we can actually cover and do a much better job from our side of the community, making sure that we're informed, but doing a good job to be a point of outreach for even people that don't know. And
for sure, for sure,
what it is.
My first thought was, why did the prosecutor not find these things out before he posed these questions? Were they just questions on the fly, or did he just not educate himself or care to prepare to educate himself?
I think he thinks he knows.
Or he just thought he knew.
Yeah, I think he thinks he knows.
Even in personal experience, I've seen a lawyer get up and pose questions and he had no clue the subject he was talking about and tried to be an expert on it and obviously had no clue the reality of the situation.
You're absolutely right, Summer, and that's the failure on his part for not knowing. As a prosecutor, you certainly have experts at your disposal. At taxpayer expense, I might add. It's not even that you have to go out of your way to find somebody that could educate you on this stuff. And there's really no excuse for going into. One of the basic rules of trying a case is you better know the answer to the question before you ask it. And
right.
He's been surprised left and right on a variety of basic things that I think will end up coming back to bite him. But we'll see.
See how that goes. Yeah.
All right, let's throw just real quick before we get too deep in this. We'll just throw a couple of quick questions up there. So we're from Christian Arrington. So the training like you received from Paramount should be federally accredited. Perhaps it would establish a standard legally. So I'll throw my 2 cents in on that, and I'll let Bill. So from my perspective, the only issue that I have with that is that once you start standardizing, especially a federal standardization, they're going to start using that, in my opinion, to limit access to firearms. So that's my only. I think that is a slippery slope. I'm a big proponent of constitutional carry. I think that you should be able to have access to your firearm at pretty much any time without training. Now, do I think that it is irresponsible to carry a firearm without training? Yes, but just like any other legal right, my problem is treating the Second Amendment like a second-rate right. Anything that you can or wouldn't do to the First Amendment or any other amendment, I think you should treat the Second Amendment in the same way. And for whatever reason, we haven't allowed that. You wouldn't require training before you allow somebody to go and protest. You wouldn't require training or anything else before you allow somebody to get on, social media and spout their. Of course, we're moving in that direction too. But that's my only concern about that, and that's how I feel about that. Bill, what do you think?
Well, I agree with you. But let me say the caveats just so I can get them out of the way, Gary. We have this on tape. I am not the lawyers of anybody listening to this video. So I don't want anybody to think I'm their lawyer. So I'm not here. I'm here on my own part trying to educate folks. But what I'm always afraid of in these sessions is that somebody's going to get into an incident and say, Bill Powell said I could shoot that guy at that time. And he's a lawyer. And I'm like, what? I never said such a thing.
For
So
the
I'm not here for
record,
my
Bill
firm, Steptoe
Powell is
Johnson.
not
Or
telling anyone.
with that said, I agree with you. I think it'll be impossible anyway, because by and large, the carry permit system that currently exists is all state run. Each individual state has its own standards and accreditations. Now, the training that your outfit gives, Gary, and you may be transferable to another state. They may, in Ohio, they may accept your training as perfectly adequate for what their training requirements are, but they can make that consideration. And a lot of times the training is just, you have to be trained by an NRA certified trainer. They all have their own standards. So training can, in many instances, go across state boundaries and the like. But as far as actual firearms training being federally accredited, you're right.
Or standardized.
Or standardized. I think.
Yeah.
I mean, some states have stand your ground laws. Some states don't. I mean, you'll get into all kinds of situations that you don't want to get into. I mean, a lot of states don't allow, or not a lot, but several states don't allow, magazines more than 10 rounds. It's just a quagmire of rules and regulations across states that would make it impossible.
Yeah, no, I agree. And a lot of people liken it to, having a federally recognized driver's license, which there again, driving's not a right. And I think we got to make sure that we're very careful to not start treating the use of a firearm and or just the Second Amendment in general as a privilege. So I think a lot of those things are with good intentions, but I think they're going to end up in a bad spot.
Yeah, and I think just as a follow-up, I think with the way we do it now is almost better in one sense, and that is that West Virginia, for instance, I have a concealed carry in West Virginia, because there are what's called reciprocity agreements with other states that the Attorney General of West Virginia negotiates. My carry permit is good in other states, and they have a list in the Attorney General's websites on which states they're good in. You still have to know the laws of those states. But oftentimes my carry permit is perfectly legitimate in other states, as those states' carry permits would be good in West Virginia. You just have to know which ones.
No, 100% agree. Yep. Ed asks, Mr. Powell, what are your thoughts on the various CC insurance programs?
Which mostly provide bail and legal expenses.
What do you think about those types of things, Bill?
I have one.
Okay.
I have one. The cynical side of me would say anything that pays your lawyers money, I'm in favor of. But in all seriousness, a quality lawyer in the event, God forbid, that you're in a situation where you have a deadly force encounter that you're the survivor of, those legal issues can become very expensive. I have no doubt that the Rittenhouse defense, which is the case we mentioned earlier, is in excess of $100,000 legal fees. I have no doubt about that. Maybe more. And plus the bond, which I think they set at $1 million, and you have to, put 10% of that up for purposes of being out on bond. So there are a number of good insurance programs out. I'm not going to recommend one in particular. You have to figure out what's best for you based on deductibles and what they cover. But I've seen 2 or 3 that are pretty good. They're really not that expensive. And I think the risks are certainly low as far as being in a deadly force encounter. But the risks of a fire at my house are pretty low too, but I still have insurance for it. So it's those things that you can't predict happening. And I expect most people who are involved in a gunfight, the first things out of their mouth say, I would never thought it would happen to me.
100%.
Or being a victim of a crime.
Yep.
We never thought that would happen, but by God, it does.
Yep.
This is actually an excellent question. This is one I've seen a lot of, and I definitely don't even begin to know the answer. What's your thought on this one, Bill?
So the question is, if you modify a pistol trigger job, that'll be held against you in the court if you use your pistol in self-defense. That's not necessarily true. It could be tried to be used against you. But the real issue is why you modified the pistol. There's a lot of good explanations why you would do a trigger job, and 99 out of 100 are not incriminating in any sense of the word. Now, there are other things that, people do that could become more problematic. Like I have a friend who he's going to carry a gun, but he's going to carry a 44 Magnum. That causes issues beyond, self-defense. Or you have, you're defending your home, and the sticker on the front door says, "Kill them all, let God sort them out." I've seen that. Those kinds of things are much more difficult to overcome than doing a fairly straightforward modification of a pistol, which quite frankly is not that uncommon. People do it all the time because they use their firearms for target practice, or the trigger doesn't work as well as they want to. And so that's 99 times out of 100. It's not really an issue.
Yeah, and I think probably in the past, when it was much more rare, that probably have more of an influence on a particular judge or jury. But today, I think you see it's so prevalent that there's 1,000 different viable reasons that have nothing to do with self-defense that I think you come up with to say, hey, this is why I had this, and it can be safety, training, 1,000 different things. So,
Gary, and I expect, Gary, you could speak to this better than I can, and that is that more likely the question is be somebody from Gary saying, "You want a 2-pound trigger on your carry gun? Why?"
Right. Well, I actually recommend a 2-pound trigger in your carry gun.
Okay, well, whatever. But you know what I'm saying.
No, 100%. No, hey, Christian, I know you were trying to clarify. I think we understood your question, and I know it wasn't. I'm just kind of playing the devil's advocate on that one, so 100% understand where you're coming from on that. Let's see. This one?
Yeah, sure.
All right. Bill, do you feel it's more important knowing the legal aspects of lethal force or having the skills to protect life? Well, I'll let you cover
This
that,
one's
Bill.
easy. I think they're equally important.
That's my
You
first
shouldn't
thought.
carry a gun without knowing the legal aspects of why you're carrying it and how you can carry it. And you certainly shouldn't just know the law, because then you'd be just a lawyer carrying a gun that you've never gotten training to use. So in either scenario, I think is bad. And you're doing yourself a disservice by doing it. When I've told people that have purchased firearms and they come to me for advice, I said, if you don't plan on getting training, don't carry the firearm. If you don't plan on finding out what the law is, don't carry the
Don't carry
firearm.
the firearm.
Leave it at your house.
100% agreed on that. It should be pushed as a holistic approach, and we don't do that nearly enough. We're real good in this industry at pushing gear. We're really good at industry at pushing new guns, but we're not that good at taking a legal and or holistic approach when it comes to training either. So those are all good points. Let's see here. So Bill, what do you think as far as when it comes to what do you think, I guess, is when it comes to the legal aspects, what is the thing that you often see is probably most misconstrued or
The biggest misconception.
misconceptions when it comes to self-defense law?
Well, I think you touched on it a little bit earlier, and that is that a gun is a tool. It's I hate to say it this way. It's not a license to be stupid. And it's, I've seen people all of a sudden carry guns and think that they are now, they have rights that they don't really have. Let me go just through the basics. Number one, in West Virginia and most every state in the country, you cannot legally use the right of self-defense as a defense if you're the aggressor. If you start the fight, you can't use self-defense then because somebody gets the better of you after starting the fight. You will never win, ever. So that's always something to consider. You can't be an ass with a firearm and then claim later that I was self-defense because the guy, all of a sudden, I didn't know the guy would be able to kick my rear end. So now I used a gun and got out of it, and that's the end.
Or it's even like saying, it's self-defense because I pulled a gun out on him and he pulled a gun out on me and I shot him. It's along those lines.
Exactly right. the other thing I'll clarify, because there's a lot of misinformation out there amongst not only the citizenry but even government people, is a so-called stand your ground principle, which is kind of a misnomer. I mean, that's Florida and some other states use that actual phrase, stand your ground, and what that means is you don't have to run away. And in West Virginia, it's a duty to retreat or not duty to retreat. In West Virginia, there's no duty to retreat in West Virginia if you're legally in the place that you're allowed to be with a firearm, and you get approached in a situation or a dangerous situation presents itself. You have no legal duty to leave. Now, with that said, that may be the smartest thing you can do: leave, rather than put yourself in a situation where you actually have to pull the firearm. So as long as you're not the aggressor and you are legally where you're allowed to be, West Virginia has a no duty to retreat law, and that's been the law for 100 years. So that's always something people ask about, because they talk about the fact that, well, you didn't run away, you could have escaped, you didn't go hide in the bedroom in your house before you shot somebody if they entered your house, those kind of things, and that's all gets caught up in the storyline, and it's really not the law. So the other thing is that, and you see this a lot, everybody tries to judge these events, these shooting events, on what we finally know about the case. After the fact events, the kid had a toy gun, or wasn't loaded, or whatever the case may be, or he didn't have a gun at all, and it was dark, and he had something else that looked like a gun. And the narrative becomes, police officer or citizen shoots unarmed person. Okay. Mm-hmm. And it's such a false narrative, because certainly in West Virginia and in a lot of states, you're judged, and the jury in a courtroom would judge you by what you believed at the time, not what was found out later. So if a guy was holding an empty gun on me in an alley, or it was a fake gun, and I used gun in self-defense and killed him as a result of that, I'm no worse legal position than I was if it was loaded, because the question is what was reasonable for me to believe at the time, not what's found out later, after the fact, after the incident is all over. So those are kind of some of the things that I see a lot of confusion about in these scenarios.
Yeah, the other on the flip side of that, Bill, I think a lot of people, or one of the aspects of self-defense that I find kind of important to understand, is also disparity of force. Can you talk a little bit about that, as far as actually using a firearm and or lethal force against somebody else that is not necessarily armed?
Oh, absolutely, and that's a really great, excellent point, and people don't realize the issue there. First of all, generally speaking, and just as a general rule of thumb in West Virginia and a lot of states, you can't use deadly force for words. In other words, if somebody's calling you an idiot, you have to use words back. So words are met with words, fists are met with fists, etc. There are a few exceptions to that, and disparity of force is one of them. And Summer can kick my butt, I know, but I'll just use her as an example. If Summer is confronted by a man that's 6'4", 230 pounds with his fists, that's a vastly different scenario than Gary being confronted by a man that's of that size with his fists. Mm-hmm. So that's a good example of disparity of force. Would Summer be able to, in that scenario, use a firearm to defend herself? Probably so, under the law, because the disparity is so great. Similarly, if and you see this, as in today's day and age, you'll see this more often. If you see a gang of people, 5 or 6 people, or some more than one person, going after somebody who is armed, but the other people aren't armed, but you have more of them, you have a whole crowd. Oftentimes, the person with the firearm has the right to use that firearm because of the disparity of force. It's reasonable to believe that, notwithstanding the fact the others don't have a firearm or some kind of deadly weapon, that they could still inflict serious bodily harm or death upon them because of the sheer nature or force of their number. So those are examples of disparity of force that may allow the use of deadly force and have a reliable self-defense argument.
Yeah, no, I think that's again, that's definitely one of those aspects, especially for women to know, and definitely for situations with where you have, you know, these riot events that we're seeing more often, where, you know, you have
Gangs.
business owners or homeowners trying to defend themselves, and of course they're going to be very hesitant to shoot at someone that's not necessarily armed. But when there's, you know, 100 of them and they're burning down the business next door, you know, there again, that is obviously doesn't mean you're not going to get in trouble, and you're probably going to be prosecuted in those cities if that's going on. But I think that definitely is an aspect that most people don't know, and I think they should know. So.
And I think it gets a little grayer in some of those issues, Gary, because one of the rules that certainly in West Virginia and most states, I think except in Texas, which I think all bets are off. But I think that by and large, you cannot use deadly force to protect property by and large.
Yeah.
So
Does that apply to
notwithstanding
your home?
What's that?
Does that apply to your home?
Well, let's get to the home in a second, Summer. That's a slightly different scenario. But if somebody's running away with my TV set, okay, I'm not permitted to shoot them in the back to stop them from running away from my TV set. Similarly, if I have a store and they're looting my store, but I'm not in any physical danger, the opportunity to use deadly force in those encounters is going to be greatly frowned upon in the legal system, and your right to self-defense is not going to be the same as if they put you in seriously threat of your body, whether by serious injury or death. Now, if they were trying to set your store on fire with you in it, and that's what they were doing, that's a different scenario.
And that's
they're trying to kill
more
you.
along the lines of what I was. If
Right.
they're showing deadly intent, right? If it's a group of people that are not necessarily armed, but maybe, you know, they have a Molotov cocktail in their hand and they just set the other place on fire, and now, you know, you're there. I don't know. It definitely gets into a lot of gray areas, and it's basically scenario based. So that's
yeah. And to get back to Summer's point, I think, you know, she raises a good point. When your home is that's a different place. And if somebody's broken into your home, they've already committed a felony. So your rights are expanded greatly at that point. Now, of course, the question is whether or not, if somebody's just, you know, taking your TV set, whether that justifies you using deadly force. Those are maybe perfectly legal, morally questionable, maybe. It all depends on the factual circumstances. I've had that situation where I've had somebody in my house that I didn't know was there, unbeknownst to me at 2:00 in the morning. And luckily there was no deadly force encounter. But if there was, I probably, would have had a decent defense in that situation.
all right. Jerry Parker asked for self-defense, defensive ammo, or FMJ ball. I know what the answer that I would give. What's your take on that, Bill?
I love this question. This is the Thanksgiving dinner question.
Yeah.
This is you carry hollow points, and I can't believe you carry hollow points in your pistol. I said, I'd carry nothing else. That's the general response I'd give, because what I explain to people is, one, I have a right to use my firearm, and in so doing, I want to stop the threat. I have a much better chance of stopping the threat when I have ammunition specifically designed to stop the threat, which, self-defense ammunition that's the way it's designed. It's also designed to at least give a little bit more protection inside a home or other places where it's going to travel potentially through somebody and into another room or somebody else that's behind them or otherwise. And, we've done enough of these tests, in the range that it's hard, even in a hollow point scenario, from it to going through multiple walls in a building. But at least they're designed, if you actually hit somebody, to mushroom out and do the damage and not exit at the same velocity that a full metal jacket type ammunition would do. And you know, quite frankly, a lot of police departments carry defensive ammo.
Yeah.
Some are banned from doing it, but they do it for a reason. And I have no problem at all doing it. In fact, I would encourage anybody that carries a firearm, at least in West Virginia, that you ought to have defensive ammo in that firearm. And as I expect what Gary would recommend also, even though it's more expensive, you need to fire it and see how it shoots to make sure it A, shoots through your gun, and B has the kind of accuracy and effect that you want it to have.
Yeah, they've spent a lot of time, research, and money on ammo in the last few years, really focusing on, the terminal ballistics, exactly what you're talking about, right? So there's a lot of really good ammo out there that is designed to do just that, to not overpenetrate, so that we have the greatest lethal effect on the target that we're shooting at. But if it does hit them and we have to worry about things that are beyond them, the idea there is that it's going to dump most of that energy into the target itself. And definitely look into not just hollow points, but also frangible rounds. But, it's funny you mentioned this. This was actually a line of questioning that the prosecutor in the Rittenhouse case was going down, and he was trying to almost flip that scenario, because Rittenhouse was using Full Metal Jacket. And he was basically essentially making the case that, you were intentionally using Full Metal Jacket because you were planning on shooting as many people as you could, hit one target and go through. And that was where the comment came from with, basically what he was trying to take the road was, you should have been using hollow points, because what he said was they explode inside the target and they don't exit the target, which obviously is.
Do you sell that exploding ammo, Gary? Because I haven't seen that. I mean, that's extra. You can pay extra for that, don't you?
That's a little HE rounds that we can put on our stuff. I'm looking on that. Now, I guess, again, I've done a lot of testing. There's a video, folks, if you haven't checked it out. One of our earliest videos that we ever did was on frangible ammo, and you could almost make it wouldn't be, terminology wouldn't be correct, but it would be closer to exploding in a target than an expanding round of any type would be. But there's some really good options for frangible ammo when it comes to especially with inside of the home, or if you have real concerns about overpenetration. But again, do some research. There's lots of rounds out there. There's new ones coming out every day. But then on top of that, take whatever they said and then go test it yourself as much as you can. And there's some easy, cheap ways that you can do some testing. Like you said, making sure that ammo runs reliably, because there's a lot that won't, especially on some of these smaller guns. There's lots of ammo that won't run in some of these compact guns. So make sure that you're checking that out, because they have a much steeper feed ramp on that. What was the question?
Real quick, Ed was wondering if Bill had any recommendations on books or classes or any other educational resources for clients to pursue.
Yes. Well, there's all kinds of books out there. Masad Ayub is a guy that I've followed before, and I've read his books and talked to him about self-defense stuff and the law. I've even talked to him in an expert capacity on occasion about particular cases. But I can get to Gary some of the resources that I've used and get you the specific titles. There are some books that anybody that carries, for instance, ought to have. One of them is I can't remember who puts it out, but there's a summary of firearms laws in each of the 50 states. And it's a 50-page book. There's one page in every state, and it shows you how you can travel with a firearm, what the laws are with a firearm, how nice they are to firearms owners in that particular state, how much of a good or bad state it is from a firearms perspective. If you do any traveling at all, you need to know that kind of stuff. If you live in where we live in Martinsburg, West Virginia, and we could drive 10 miles in 4 different directions and be 4 different states. You need to know what you're doing in those states. For instance, I know if I'm going to Sam's Club in Hagerstown, Maryland, I'm just not bringing the firearm because God forbid I get pulled over and I don't have it exactly right. They're looking to put me in jail. And that's just something you need to be aware of. And DC is close by you. I would never bring one there. Pennsylvania, I feel fine. Virginia, I feel fine. Ohio, I feel fine. But I also know the specifics in Virginia and Ohio and Pennsylvania enough that if something happens, then I know what I can do and what I can't do. So they have these books that provide some brief summaries of some of the basics in each of those states. That's certainly a resource that I would recommend. Obviously, from a technical standpoint, classes like Gary's are, important. And I mean classes, and people don't want to hear this, but because Gary, trust me, Gary doesn't pay me a commission to send people to his classes. But this notion that I'm going to take a 1-day class, and that's all I'm ever going to need to know about firearms, you're fooling yourself. If you don't understand how to fix a malfunction and do a reload and under stress and all those kinds of things and be pretty proficient at it, those are gaps in your training from a technical standpoint that you need to fix.
I remember even from time of us dating back when we had paper maps and atlases, the pre-road trip, every time we would Google every state we were going to be driving through and check the laws and check where we could carry and where we needed to lock it up. And it was just part of pre-trip planning. So,
Yep. And in most of the states where we couldn't carry, I just had Summer put it in her purse. She was doing the time on that one.
Throw me under the bus in a New York minute.
No, but no. Hey, as a matter of fact, so Dan, I'm sure you're listening on here, and if you're not, you're in trouble. So, but Dan's our web guy. One thing I want to commit to is we're going to actually build out a page on our website where we'll throw up some of those educational resources that we recommend, that Bill recommends, and we'll try to continue to build that out. As well as maybe develop some more curriculum, probably with Bill if he has the time and availability. Those are definitely areas that I'm very passionate about doing. Just haven't had the time, and obviously in that particular, I don't have the expertise. So that's definitely something that I think most people, would be, extremely beneficial. But on top of that, I think from a business aspect, it makes sense from I think people would pay for that. We could actually build some things out and throw it up for a few bucks on the website or something like that. And I think people would appreciate that. And it helps support what we do as well. And hopefully I can make Bill rich or something. All right. So, let's see. Paul, what do we got down here? Trial being in the media. What's your thoughts on mentality of the crowd with multiple aggressors? Has the trial changed your opinion in advising people to stand their ground? I'll let you handle that one.
Well, the multiple aggressors one, I think we've covered a little bit in the sense that the disparity of force issue associated with your right to self-defense. The Rittenhouse case, obviously the one that's going on in Wisconsin, it's kind of the petri dish of this kind of law and seeing how it gets out of hand. Let me just say this. There's a lot of blame to go around in that case. Number one, if you're caught in the crowd and you live there and you're being put in a situation where you have to use deadly force, that's one thing. If you're 17 years old and you travel to a different state to get into the crowd with a firearm, that's something else. And let's take the legal part of it out for a second. There's also a whole lot of common sense that goes into being a firearms owner and carrier. By and large, if you can avoid a scenario that you'd be putting yourself in the possibility of using deadly force, you probably ought to take that opportunity. Just avoid it. Obviously, to the extent you are stuck and you can't get out and you are protecting yourself and or your family or others, well, that's a different scenario. And, the rules then are applied. I think everybody who carries a firearm ought to have some kind of bright line rule in their own mind as to when their hand's going to that firearm to take it out of the holster or to pour it up if it's a rifle. And to be honest with you, everyone's rule is going to be a little different, and the circumstances are going to determine whether or not that line is going to be crossed for you. For example, if I'm by myself and I have an easy avenue of escape, and I can get out of there without having to shoot somebody, I'm probably going to take it. If I'm trapped and I have my wife who is unarmed or a child that I need to protect, and we're trapped, the chances of me using that firearm have gotten significantly greater at that point, because then the factual scenario is different. I can't get out and I have people to protect. So everybody has to have that fine line. And sometimes I go to the problem is, and I'm not nearly as trained as Gary, obviously, but even in restaurants, I'm always knowing where the exits are, and I kind of see where people come in. I always like my back to the wall, those kind of things. So it's really kind of stupid stuff, but it's not.
Yeah, no, I always make sure that I can see the exits, and then I make sure that my wife and kids are in front of me, because you got to have cover. So
human shields. I think human shields are important. But I usually just try to use strangers, Gary. I don't try to use the people I'm dining with.
I try to stack them up, just to.
But no, for real, we all know to plan our seating around where we know Gary will want to sit.
Yeah. So, I mean, the easy scenario for people to think about is, the defense of others, which is allowed, by the way. You can defend somebody else with deadly force. You essentially are judged by standing in the shoes of the person you're trying to protect. So I always give the example of the local 7-Eleven, where you're in the back buying a quart of milk, and some idiot comes in and is robbing the store. And so the question is, and you're armed. When do you intervene? Do you intervene to protect that cashier that is being robbed? Well, for me, it's a fairly straightforward scenario. If the guy just comes in and says, "Give me all your money," and doesn't pull a gun, I'm probably not intervening. If he pulls out a gun but doesn't use it or doesn't point at anybody, at least I'm thinking about intervening, but I still may not intervene. If he puts a round in the ceiling and says, "Give me all your money or I'll shoot you," well, now I'm pretty close to intervening. And if he shoots one cashier and points the gun at the other one, I'm probably definitely intervening at that point. So you can see, depending on the factual scenario, how your actions will be determined. Now, it may be the guy comes in and says, "I'm going to rob the store. I'm going out the back door and calling the cops." That's maybe the best scenario, and that's probably the one I hope for. Obviously, it's the easiest one, and hopefully the one that will end up with nobody getting shot. But so it all depends on the factual situation and where your line is.
This is a pretty good question. Yeah, I know. I have some thoughts on that, but take that one, Bill. What's your thoughts on open carry versus concealed carry?
With respect to the self-defense, no, there's no difference in open carrying versus concealed carry. My only comment to this, and I guess it's controversial with some people because we get into this big constitutional argument. If you want to open carry, that's fine, but why would you? I mean, if you're going to carry a firearm, it's concealed for a reason. I don't want to give advance notice to anybody that I have a firearm. What am I doing that for?
It makes no sense.
I mean, it just doesn't make any sense to me. And I think you're asking for trouble. And I'm not saying they're right. And the people are going to cause you trouble. And I'm not saying as a matter of principle that you couldn't do it and you're going to show your rights off. Fine. If that's what you want to do, that's fine. People say all kinds of stuff too. And it's certainly within their rights under the First Amendment. Not necessarily something I would do, depending on what they say. But but from a self-defense standpoint, no, it makes no difference from whether you're open carrying or concealed carry. It's all a matter of when and how you use the weapon.
Yeah. So, I have a lot of mixed feeling with everything you said. 100% tactically, it makes no sense, right? So you were definitely speed, surprise, violence of action is definitely what's going to want to fight. And you were taking away all surprise. And you're probably going to be the first target. With that being said, I also have a problem with the average, person kind of. I see a lot of Second Amendment folks that are kind of beaten down on these folks. Hold on, we got some feedback going on somewhere. So, anyways, the issue is, I don't want to beat up on people that feel that they need to open carry. I like it in the fact that we probably need a little bit of activism, if you will, on our side, because there's a lot on the other side. And the other thing where again, I wouldn't do it, but I also don't want to turn carrying firearms into such a taboo to where people always freak out. I actually want to see, I want my
Normalize
kids
it.
to kind of see people with firearms and not freak out.
Yeah.
But there again, you know, from a tactical standpoint, it doesn't make sense. It's not something I'm going to do. But also, I see a lot of folks just trashing on people that want to open carry, and you know, it doesn't make
their
sense,
choice.
but it's their choice.
Yeah, I don't have a problem with it. Just, you know, the only question is whether, you know, if I have a conversation with them, I'll usually say, "Hey, why are you doing it?" And you're just curious why. I mean, is it something? Is it a political statement? Is it something you just want to do? I don't have any problem with it, and I don't get freaked out about it, obviously. But and I think, you know, the point you make of people seeing it more to some extent will make them, at least it's not as big a deal.
Yeah. No, that's
By the
So,
way,
yeah,
if you're gonna go, you want to see guns, go to Europe. Every
Yeah.
police officer in the corner standing there with an AR.
the same thing with the Middle East. I just got back from Jordan. Everybody's carrying around either they're carrying M4s, they're carrying MP5s. You know,
Yep.
and honestly, if you go down to Mexico, they're doing the same thing.
Sure.
Let's see. Paul says that he's traveled thousands of miles to assist in hurricanes. A medic. We're saying is if it's civil unrest, we should stay at home and not provide assistance. Do you think that is? I don't think that's what he's saying.
Yeah, that's not what I'm saying. Absolutely. I recommend people who, particularly people with medical training, to assist as many people as you can. I was a EMT for a while, and I think that's really important work. So no, I think you absolutely should provide assistance. That wasn't the issue I was addressing.
Yeah, that's enough on that. All right, so yeah. Anyways, you know, let's see. Hoping the day will come. So, what do you think, Bill? What do you think the ultimate outcome? Just, I don't know if you want to speculate or not. What do you think the outcome is going to be on the Rittenhouse trial?
Well, with the caveat that I haven't watched the actual, I've seen clips, but not the whole trial. But based on everything I've read, there's going to be, it's a trial. I mean, to be honest with you, it's a dumpster fire in one sense. The trial, it's got so many weird twists and turns from not only the judge, the prosecutor, the whole factual scenario, that I think. Well, let me say, there's multiple charges. I think there's a decent chance that he'll be convicted of the misdemeanor of carrying a firearm because he's below the age of 18. He's 17 years old, carrying across state lines with a AR rifle. I think that's going to be a hard one to defeat, even with a crappy case, because, you know, they got pictures, so it's not like it's unusual evidence. With respect to the other stuff, I haven't seen the makeup of the jury, but the burden in Wisconsin, like it is in West Virginia, is once you assert the self-defense argument and the court says it's a valid argument, then the prosecutor's got to prove that your self-defense was not valid beyond any reasonable doubt. That's a pretty high standard. So, you know, if there's enough evidence, and I certainly think there's a lot of good arguments for the defense counsel in closing arguments to make that, you know, reasonable people can differ, but there's no question that there should be reasonable doubt in people's minds as to whether or not what he did was justified. Now, I will say that with the caveat, and I mentioned Gary and I were talking about this before we went on, and that is that one person being shot is one thing. 3 people being shot in a relatively short amount of time is something else. So it's a fact that, as his lawyer, that would worry me more than any other fact in the entire case, that so many things like that happened in such a short period of time. And that, at least from the prosecution standpoint, although I expect he'll not do the smart thing either in this case, and that is that, you know, to say that I'm being reasonable 3 times in a row to use self-defense or use that firearm for self-defense doesn't make any sense. That's the only caveat that gives me some pause. But to be honest, I think no matter how this case is going to go out, it's going up through appeal court, and it'll be dealt with there.
Speaking along those lines, John asked a great question earlier that I meant to bring up. So, what do you think is the outcome of the New York Rifle and Pistol Association versus Brown in the Supreme Court will be?
Yeah, it's a good question. The justices, based on the questioning, and you can't, and having given these, not to the Supreme Court, but I've given plenty of appeals court arguments where I get peppered with questions, and I walk out of those cases sometimes, and I feel like I've been, in the ring with Mike Tyson for the, last 30 minutes, but I still win the case. But if the questions are an indication, I think there's some serious questions about the New York law. And I think that come next summer, which is likely the time that they're going to issue an opinion, that New York's going to have to modify or get rid of that particular law with respect to that firearm. Now, I expect what they're going to try to do between now and then, if they read the writing on the wall, is try to modify it. And because they've done this before, New York has done this before, where the case goes up, they think they're going to lose, so they change the law ever so slightly to make it a different case, and the court could say, well, it's moot, it's no longer the same law. So although I think the Supreme Court's onto this game, they were critical of New York in trying to pull a fast one again in this one. So I think it looks good for the gun owners in this case, given the makeup of the Supreme Court.
So that particular scenario has happened several times all throughout the country. Now, is that something that the Supreme Court, can decide on, even though they've changed it, or just by like their hands are tied, they can't because they've kind of tweaked the law a little bit, just to take it out of their hands?
It depends on what the specific question is before them. If it's a broad enough question, they can go anyway. But if it's something very technically specific to that particular law, then they could very well say, well, the issue is moot. In other words, it's no longer relevant because it's not the same law. We can't decide this case because the question before us relates to a law that's no longer in existence. Now, the way to get around that is to make the issue bigger than the law. And I think that's what they've done in this case.
Yeah. So what do you think? How effective do you think that the NRAILA has been the last few years? I really feel when it comes to a lot of these cases, and I'm always shocked at how long these cases stand on the books before they're actually challenged. Is that just because it takes that long? I also don't feel like the NRAILA has been doing very much. I feel like that they tend to enjoy the issues more than the solutions, because the issues are bringing in money. What's your perception on both?
Yeah, I mean, I don't know what the specifics are of why they don't take on certain cases than others. I think there's certainly, from a legal standpoint and a lawyer standpoint, bad facts make bad law, and you're always looking for the perfect case, the best case. The Heller decision is a good example of the Supreme Court case that went up. I mean, those facts were so bad for DC that they really had the perfect storm to bring the case up, because DC looked so stupid in what they were trying to enforce. So I think it's a question of, because these rulings are so important, you want to find the right factual scenario that will get you the biggest bang for the buck, no pun intended. And a lot of these other cases, there are arguments back and forth, and what you don't want, if you're the NRA or a pro-gun group, what you don't want is some court, an important appeals court, to come down and give favorable rulings on issues that you didn't expect, or because of the facts in that case they had to rule on, and they didn't go your way. So what they're looking for is, home runs as opposed to singles, and that's what they're trying to accomplish.
So they end up spending a lot of time looking for the perfect case, victim, or
and I think
that has the most standing.
Right, and I think they're looking for these scenarios that in these particular states that are the most problematic: the New Yorks, the New Jerseys, the Californias, the DCs, and places like that are so draconian. Like, I'm sure you'll see, and I think I can't remember the name of the case, but I know there was one that a woman college student who was being raped, used a firearm on a college campus, and it was, God help her, and I certainly hope, and it's terrible that this happened to her, but from a legally factual standpoint, it's a darn good factual scenario if you can argue about campus carry.
Yeah.
It's not what you want, but it's hard to argue about it.
Yep.
And, usually when there's not campus carry, is that just because it's basically they're saying that, are they going the school, hey, they can't carry a firearm on school because it's school property, or is it because of a private property issue, or both? Or
could be both.
Okay.
In West Virginia, as you probably know, Gary, the notwithstanding the various self-defense laws and the like, business owners can prohibit you from carrying a firearm. They have to ask you, or you have to be notified of that. But
right.
They have the perfect right to ask you to leave and not have a firearm in that business. On university or college grounds, obviously, it could be a private campus or a public campus, and they can, in many cases, create their own rules. Even on a public campus, you have public areas of the campus, and you have private areas of the campus, or you have restricted areas of the campus, and you have non-restricted areas of the campus, and it just becomes a patchwork. And quite frankly, as a concealed carry owner, sometimes it's harder to keep straight on the patchwork of where you can and where you can't. It makes it nearly impossible because you don't want to break the law. By and large, most 99% of us want to follow the law. We're not looking to violate the law or get in trouble. We want to follow the law. By the way, unlike the criminals that are carrying guns who don't really care. But
Right.
Be that as it may, the patchwork makes it difficult, no question.
Yep.
Well, even, DC offers it. And by the way, there's a couple of things we need to do to finish up to where we can offer licenses for Washington, D.C. But I'll tell you, even you talk about a patchwork, that's, you can carry concealed in D.C.
If you get the permit.
But then you can't go on like the mall. You can't go on almost any like federal property. I don't even, I guess you can drive around with it in your car. But the moment you get out and do anything, you're probably on some shady legal ground.
A hoverboard or something you can
Yeah.
go over to the next spot.
Yeah, they make it difficult. There's no question about it.
Now, going back to West Virginia and a lot of this, from what I understand too, like if a business says, if there's a sign on the window that says, no guns allowed, that's not enforceable as of, you can get in trouble if they do see you on it. Now, if they see you with a weapon, they can ask you to leave. And if you
Correct.
don't, then you can be charged with
Trespass. Right. That's exactly right.
Okay.
Yeah. So, I mean, there goes back to the open carry. I've known people who've done this. They intentionally go into businesses they're not supposed to carry and they open carry, and they're making a statement at that point. And I understand the point. And if you want, and there are remedies to try to change that scenario, getting into a showdown with a business owner, and usually, by the way, not even the owner, just some poor schlep that's working for $9.25 an hour,
right.
Trying to do their job. I'm not sure really gets us anywhere.
No, I think it doesn't. And that's another one of those laws too, because I know in some states that is enforceable, right? You can actually get, if you're caught with a weapon on the premises, just right off the bat, you can get into trouble. So that's one of those
for sure
laws that are different from state to state. So that
gets
pretty shaky down there.
Yeah, I mean, so like let me give you another example of laws in different states. We were talking about the home earlier. A home in West Virginia is pretty well defined, but in Ohio, the question is whether or not your porch is part of your home or not. In Florida, whether your porch is a home, and one it is and one it isn't. Some places the trailer that you live in is a home. Some places it's not. So those are the kind of intricacies of the law that you probably ought to know about if you go to these other states to know exactly what you're allowed to do and what you're not.
It's my understanding also that in West Virginia, any detached outbuildings from your home do not count as the home also. So say a detached garage.
That's generally true, although you would still be under the generally, no right. You still wouldn't have a requirement to retreat as long as you were legally where you were. So that would be just like being in any other public place.
Gotcha.
That's good information there.
Yep.
Research.
Bob was kind of late to the show,
Yep.
so he
No,
didn't hear the
Bob
answer
wants
to
to
this
know, how do you
earlier.
research and learn what laws are in your state? Become a lawyer,
Yeah.
Bob. Jesus.
It's a good question.
Not that hard.
And that's a legitimate question because it's very different in different states. And I'll give you an example. West Virginia is basically there's a couple of statutes in West Virginia, but by and large, the laws in West Virginia are case law. That is the court decisions. You have to read the court decisions to know what the law is in West Virginia. Now it's fairly established in West Virginia since we were formed as a state, and there's been in excess of 500 self-defense law decisions in West Virginia. I've read nearly all of them, from the guy that from the time people were shooting guys off the horse because they were messing with their wives, to current self-defense stuff. And really, West Virginia law hasn't changed that much. Florida, for example, everything is codified. That is, everything's in the statute. You pick up the statute book and read everything on self-defense law. It's all in there. West Virginia does a pretty good job. If you go to the West Virginia Attorney General's website, they actually have a publication that you can print. It's not that long, on your computer, and it talks about the firearms laws in West Virginia, and I believe it has some self-defense stuff in there, and so you can get access to it. And some of the books that I'll pass on to Gary, the resources there are, those are printed off every year, and they have a summary of the laws of all of the states, including West Virginia, and it will give you certainly some general guidance.
Yeah, and again, folks, what I'm going to do is we're going to try to start cobbling together some of these legal resources,
Even
and
just websites and links that we can put up on a page. On the
we'll throw up
website.
on a page and do the best we can on some of this stuff. So
yeah, I'll pull up some links for you, Gary, and I'll email them to you or something.
Okay.
And then you can use them or look at them and see if you want to put them up.
No, I appreciate that. All right, let's see. Yeah, nothing wrong with that. Yep. Generator guy, thanks for coming by. All right, so what else you got, Bill? Anything else that I know you got like the club to hit tonight. Got to do some hustling, some pool, some normal Friday night snapping necks, cashing checks type of thing.
No, I think that let me just mention one other thing that
no, go take your
I
time.
mentioned a couple of things.
Sure.
Number one, domestic violence. West Virginia obviously has a rule that even if you're convicted of a misdemeanor domestic violence, you're prohibited from having a firearm. But on the other flip side of domestic violence, the victims of domestic violence have the right to legal self-defense and deadly force encounters, actually more than most people. There's a case in West Virginia called Hardin, and that particular case, a woman had been abused by her husband in their marriage for a long time, months, maybe years. And he threatened her, he beat her, and threatened her with pointed a gun at her every now and then. And on this one particular occasion, she was threatened that evening, and he was drunk, and she had her kid with her, and actually a kid's friend who was staying at the house. So the guy, her husband, falls asleep drunk on the couch, passes out. She goes downstairs, pulls the shotgun from the closet, cocks it, shoots him where he lay in the bed or on the couch, kills him. Okay. She's tried for murder. Question was, did she have the legal right to self-defense? Was she reasonably in fear of her life or for serious bodily injury? The jury convicted her. The Supreme Court let her out and said she had a perfect right to self-defense. Doesn't matter if the guy was standing there pointing a gun at her or not. Based on the history and based on what her reasonable fear was with everything she had been through, she had the right to deadly force. It's not like that in all states, but that's, it isn't like that in West Virginia. So I can always see who the problem children are in my classes because I get grimaces from certain guys in the audience, like they're all of a sudden now worried that they have firearms in their house. So it's called a bat.
My household, that would have happened once, and I'd have been smoked.
That's exactly right. So it's the battered woman syndrome is basic, or defense is what it's called. So that's something people need to know about West Virginia. It's it's serious, and it's I've seen several of these cases now. I've seen them go the other way too. One in which the woman, her husband had beat her, but he had a heart attack unrelated to anything that he had done, was in the hospital in intensive care. She brings a gun to the hospital and shoots him in the hospital bed. Now, she didn't get off with that.
Sure.
She got convicted. So it's a slightly different scenario. I guess she was thinking that she would benefit from that ruling, but she did not. The other thing is that I think people need to understand, and something that's always considered in these self-defense scenarios, and it's a little bit in the Rittenhouse case, but we've seen it lots of times, and that is, how far people are away before you can actually pull your firearm and use it in self-defense. And, the old scenario goes, it takes about, from the time you recognize a threat to the time even a trained person can pull a firearm and shoot on target, it's about 1.5 seconds in the best of scenarios, about 3/4 second to recognize that a threat exists, and about what I call it the oh crap moment, like when you realize you're going to run into the back end of a car and you realize you have to hit your brake. That's the reactionary time.
Yep.
And then, but even drawing even if you're trained in drawing from your holster and hitting targets twice Gary, you've timed us. It takes some time.
Yep.
But it also takes only 1.5 seconds from a person to get from there to me for 15 feet away.
About under 3 seconds for 21 feet. They talk,
Yes.
the old Tuller drill, which came
The old
from
Tuller drill,
a legal case.
correct. And this is really important because you see this all the time where people are, they go apoplectic because the person is holding a bat or a knife. They're 21 feet away, and people are saying he should never have shot him. He wasn't even close, blah, 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 blah. Well, yeah, he was close. And by and large, the expertise is out there that, so you need to be aware from a distance standpoint, where you are to the threat. Always increase the distance. That's obviously from a tactical standpoint, that's what you want to do. But from a legal standpoint, you don't have to have somebody on top of you, pounding you to, like in the Zimmerman case, be able to use your firearm. That's not to say you can, shoot them from 50 yards away as they're running down the street, but that's something to keep in mind as time goes on. And if you're ever in that situation, so you always want to increase the distance, but don't be careful. You just be careful and make sure the distance doesn't get too close that you become the victim of a situation that you don't want to become a victim of. So that is a legal standard that's something that we deal with all the time, and something that we look at and are constantly cognizant of, and the news constantly gets wrong because they want to harp on it. So I think that's kind of what I wanted to cover, I think.
Yeah, and with that too, Bill, is both training and constantly playing those what if scenarios in your mind is what is going to give you those answers, right? How fast can I get that gun out, especially under stress? Because whatever you think you can do under normal, even whatever stress that I can put on you on the range, which is one of the big things that we, from day one, we're constantly trying to force you into scenarios and doing things to where you're having to think and make decisions under stress, which most people can't do and are not used to being able to do. But even the stress that I can put on you on a range and where you fall apart, it's going to be 10 times worse than that when you genuinely feel for your life or fear for someone else's life. So
no question.
Yeah.
And the only other thing I'll say is that one thing we never really mentioned, but I think it's important because I see cases as much on this as anything else that I see. And that is that the force that you use in a deadly force encounter has to be proportional. Can't be excessive. And what I mean by that is if as a lawyer, if I'm defending you, I'm not concerned that you put 4 rounds on target, if that's what it took to stop the threat. What I am concerned is once stopping the threat, you go over and put 2 more on them.
Yeah.
Okay. Or the threat is no longer there and you essentially, finish the job, quote unquote. That's where people get really hung up and get in deep crap because it's no longer the person at that point is no longer a threat. It may take 1 round. It may take 12 rounds to put somebody in a situation where it's no longer a threat. I'm not concerned about that. What I am concerned about is the post-threat rounds that are being put. And if you look on the internet, there are 1,000 videos out there of people doing that, and and people getting convicted where they're right up to the point where they do everything right. They've done everything legally. They properly use deadly force to stop from being injured or killed, and then they do something stupid. And it's that last idiot move that causes them to go to jail for a very long time. So I always make sure that everybody knows that you're only allowed to use reasonably proportional force, not just because it has 16 rounds in the magazine doesn't mean you have to use all of them.
No, and again, if a combatant falls to the ground and throws his or her weapon away, and they're now on the ground and they're no longer a weapon. And these are the scenarios that we do with law enforcement all the time. When I work with the Department of State, these are the exact scenario-based situation we put. And you cannot believe how many very well trained people, they just get caught up in the moment. And this starts working and this stops working. And I'm telling you, folks, those are people that have trained, that have thousands of rounds, that have done scenario-based training, that most of them already have military and prior law enforcement experience. And now they're going into the federal career, and they still make horrible, horrible decisions that you just sit there and you're like, oh my God. And you're going to make the same decisions, folks. If you are not training, folks, I'm telling you right now, I always say plan to fail. That's what you're doing. You're training to fail. So, you got to make sure that you are training, what's going on, and you have the mechanics of working the gun down to the point to where you don't have to think about that. All you're doing is putting all of your thought process into problem solving. And there again, you got to have some skills and some good judgment and some good legal counsel based on that. Hey, Chip, it's good to see you, man. Glad you showed up. Good to hear from you. Speaking of Department of State, folks, that was my old boss. All right. Before I let you get out of here, what just kind of on the last thing, Bill, if a person that is on this feed right now, if they were to get into a self-defense scenario, the moment that begins and ends, what would you say they should do from that point?
Well, it depends when we're starting this scenario. Number one, if in fact you get in a deadly force encounter, one, I want you to be the person that calls the police, not somebody else. Okay. You're the victim. Remember that, not the person that may be lying in a pavement someplace. You're the victim. Make sure that everybody understands that. If the police show up, please do not wave your gun around. Okay. All the police hear is somebody with a gun and somebody's getting shot. That's all they hear. And they don't know it's you. They don't know you're the good guy or not. You need to put the gun away either in the holster or put it on the ground, and wave and make sure everybody knows exactly who you are. Now, something I always tell people, and they ought not to get upset about it. It's just a fact. If you're in a deadly force encounter, they're going to put handcuffs on you. That's just a fact. You will be handcuffed because they don't know what the story is at that point. They're going to protect themselves, and they're going to start taking people in and trying to sort out the details. Obviously, to the extent that you want to make sure you get legal counsel. What I tell everybody is that when they're asked to give a statement in a scenario like that, is the first words out of your mouth is saying, "I'm more than happy to cooperate. I'd like to call counsel and give a statement tomorrow or whenever the case is." Because even a police officer, in as far as I know, every law enforcement agency in the country, you get at least a day in order to get your thoughts together to give a statement in a shooting incident. Because, as Gary said in a few minutes ago, when the adrenaline's going and you're stressed, you're not thinking straight. I'm just telling you right now. You will leave stuff out and you will say stuff you don't mean, and it just becomes a jumbled mess in your brain. So you need to take that time. You don't be an ass about it. You just say, I'm more than willing to cooperate, but I'm going to, talk to counsel and I'll give you a statement. And then you deal with it accordingly. So those are basically the thing. What I tell people all the time is, if you get in one of these situations, what you can't do, what you can never do under any circumstances, is leave. You cannot run. You cannot go to your house and call the police later, or think, I better report that. No, you need to stay there. The first person the authorities ought to hear about it is from you. Remember, everything is being recorded. So that first statement is pretty darn important. And what you don't want to do is flee the scene, because then what you are is guilty.
Sure.
In the minds of most everybody in the universe.
Yep.
So,
yep. And you're probably trying to get rid of evidence or whatever it may be.
Well, plus you're leaving evidence that's there that may help you.
Yeah. Yeah. No, I'm just saying a perception, like,
Oh,
yeah, they're gonna think that you were up to some, which of course that's what they would. But
and the witnesses are going to say, all the witnesses say, yeah, this guy shot that guy and then he ran.
And he left. Yeah.
And this is one of the things I was talking about, is making sure that you play these scenarios out in your mind and you make these decisions ahead of time, because just like you said, you're going to be in an emotional and physical mess when all this goes down. And if you haven't thought about this, it just increases the chance that you're going to make a bad decision that could change the rest of your life, or be negatively detrimental for the rest of your life. So you got to be informed, you got to be educated, you got to be trained, you got to think about these things and make those decisions ahead of time when you can think straight, so that when you're not thinking straight, you've already counseled that guy that's not thinking straight. He knows what to do. That's what it's all about. Make the decisions ahead of time. What else, Bill?
That's about it, I think. I mean, we certainly can, talk about this for days if we really wanted to. I think.
We got to have a couple excuses to have you back on here a few times. So we'd love to.
That's
do
fine.
That. So let's. I know you got a pool hall to go hustle some folks some money out or something.
No, I'm not.
I'm just joking.
No.
I know.
I give more stuff away I give more advice away for free on this kind of stuff than anybody else that I can imagine. So, it's really, I take it as a personal crusade to educate people about this stuff, because I feel so strongly about it, and making sure that people who are carriers of firearms or concealed carry permit people have what they need to have, and at least, and if they don't have it, at least they know where to get it, because it's just so important.
No, 100%. And that's something, like I said, we'll start dedicating some time and more resources to throw something up on the website. And if we can come up with some classes or something like that, hopefully we can do that, because this is definitely an area that we haven't put enough effort into, and we're not doing right by our clients and our just for the information. I think it's so important, and it's just lacking generally as well. So, no, hey, listen, Bill, we really, really appreciate you coming. I enjoyed the chat. Make sure that everybody hits the like button down there. Make sure you subscribe. We're going to do more things like this. We're going to continue to have great folks on. And we just appreciate everybody's time tonight. So make sure you go out there, be safe. And if you got any last questions for Bill, go ahead and throw them up there.
Bill, we really appreciate the wealth of knowledge you're willing to share with all of us.
Absolutely. Absolutely. I wish more folks like yourself, again, just no, we definitely need good sound and legal advice on the firearm side, and we don't see it nearly enough. We got too many people on YouTube pretending to be lawyers. And
well,
I'm sure I've been guilty of that as well.
Every now and then, after one of these things, I'll get a call and saying, I want you to represent me in the deadly force case. I said, why, did you shoot somebody? And they said, well, no, not yet. So my immediate comment to them is always, I hope we never talk again.
So Tac Buddy Sales asked the question. We kind of answered this earlier, Tac Buddy, but he said yes. Generally, yes. You're going to have some major legal fees, and the chance of you using that is probably very low. But if you do use it, just like any other type of insurance that you carry, you're probably talking at least a couple $100,000 in legal fees and other issues. So Bill's advice on that was yes, do some research on it. Make sure you pick the right one. We used to be tied in with who was it?
USCCA.
USCCA. We just kind of let that fade. That's something probably we need to look more into again, and so that we can offer our clients. I did at one time. I'd researched this quite a bit, and at the time they were the best option. I don't know if they still are or what else is going on there.
Yeah, they're good, but there are several really good ones, and you can do comparisons and see what you need. And you know, some of them really aren't very expensive, and some of them more expensive. It just depends on the amount of coverage you have, and like anything else, it kind of depends. How much are you willing to lose? Do you have a house that you have paid for? Do you have, you know, those kind of things, or do you? If you have nothing, and you're willing to roll the dice in a public defender, that's fine. Then you don't need it.
Yeah.
No, this is a great question, Bill. You got any places? You got a Twitter feed or anything that you post to?
Nope.
You know, I'd like to say that
that's the only place you can see him.
Yep.
you know, I stay away from social media as much as humanly possible. I'll say that.
It's probably a.
That is wise. It's probably the
Probably
wisest
wise
thing you've
thing.
said all night.
Mhm.
Well, listen, Bill, again, we really appreciate it. Thank you so much for coming out. And again, folks, we appreciate you guys coming out as well. Hopefully that answers some questions. Continue to educate yourself the best you can on all these issues. So until next time, everybody stay armed, stay ready, and we'll talk to you soon.
Thanks, Gary.
Thank
Thanks,
you, Bill.
Bill.
We'll talk to you.